Hello everyone, I am Anshika Agarwal, working as an intern in LEXIS and Company. Today I will discuss the composition and jurisdiction of International Court of Justice. So let's start. First I will talk about the composition of International Court of Justice. The Permanent Court of International Justice consists of 15 judges. They are elected on the basis of their high moral character, irrespective of their nationality. Only those persons are elected as judges who possess the qualifications of occupying the highest judicial office in their countries. They are elected for a term of 9 years, and on the expiry of term, they are to be re-elected. They are elected by the League Assembly and League Council from amongst the persons nominated by the Permanent Court of Arbitration. No two judges could be from the same nationality. The court was established at Hague and it started functioning from February 15, 1922. So now let's talk about the jurisdiction of the court. The International Court of Justice enjoys 4 kinds of jurisdiction. Number 1 is voluntary jurisdiction. According to Article 36(1) of Statute of International Court of Justice, the jurisdiction of court includes all the cases which the parties refer to it. Thus, if the parties refer a dispute to this court, the court's jurisdiction and decision of the court shall be binding upon the parties. Second one is optional jurisdiction. As per Article 36(2) of the statute, forces optional jurisdiction upon the court. This clause provided that the states parties to the dispute may force compulsory jurisdiction upon the court by making a declaration in respect of any state which also accepts similar obligations. Thus, this can be done even without any special agreement. This is called the jurisdiction based on optional clause, or under this even a state may confer compulsory jurisdiction upon the court in the following subjects. Number 1 is interpretation of treaty. Second is any question of international law. Third is the existence of any fact which is established would constitute a breach of international law. Fourth one is the nature and the extent of preparation to be made for breach. Article 36(3) declares that such declaration referred to in Article 36(2) can be made unconditionally or on conditions of reciprocity on the part of several or certain states or for certain time. Thus, the parties making declaration under Article 36 may make such declaration with certain reservations or conditions. Third jurisdiction is advisory jurisdiction. Article 96 of UN Charter authorizes the General Assembly to grant permission to the specialized agencies to seek advisory opinion from the International Court of Justice. And further, more court can give advisory opinion to the Security Council and General Assembly as and when they demand. The court has obtained a great importance with regard to its advisory jurisdiction. As pointed out by the Zoni, that the principle underlying advisory jurisdiction is that qualified international organs are entitled to ask the court for an opinion on legal question, that the opinion itself not constitutes a decision with which anyone is legally bound to comply. According to Dr. Nagendra Singh, the advisory opinions of court are not binding, yet their authoritative statement of existing law and their disregard will lower the prestige of the court. Last one is transfer jurisdiction. In addition to the above jurisdiction, the court has another jurisdiction known as transfer jurisdiction. According to Article 36(5) of the court, declaration made under the statute of Permanent Court of International Justice and which are still in force shall be deemed as between the parties to the present statute to the acceptance of the compulsory jurisdiction of the International Court of Justice. So what is the law applied by the court? Article 38 of the Statute of Permanent Court of International Justice provided that the court shall decide disputes submitted it to in accordance with the international law and shall use the sources of international law in the following order. Number 1 is international convention, second is international customs, third is general principles of law recognized by the civilized nations, and fourth one is judicial decisions and the teachings of the most highly qualified persons of the various countries as subsidiary means for the determination of the rules of law. So what is the evaluation of the work of International Court of Justice? The Permanent Court of International Justice contributed much for the development of international law. For example, in S.S. Wimbledon case, the court developed the rule relating to strict interpretation of international instruments and their validity in Tunis and Morocco Nationality Decrees 1923. The court dwelt upon the change, the meaning and scope of domestic jurisdiction. In Drenching official railway case, the court developed the law relating to rights of individuals under international agreements, and in Eastern Greenland case, the court developed the law relating to occupation. Rousseau has rightly marked that from as experimental beginning, it established the point that the permanent judicial organ is both feasible and necessary, even without going so far as to be accompanied by any true compulsory jurisdiction. It may be, however, be noted that the court had certain weaknesses and limitations. Russia and America never became the parties to its statute. Moreover, even those states which became parties to its statute did not submit their important disputes to it. So now I would like to conclude myself by the words of Corbett. It was never allowed to decide major issues of international conflict. But the importance of its work is not to be measured by the gravity of disputes submitted to it. Legal precedents of lasting significance may be established to the adjudication of cases where the immediate stake is small, and the judgments and advisory opinions of the Permanent Court of International Justice, while not formally binding upon that or any other tribunal, is written in Article 59, stand today among the most authoritative statements of the law of nations. So this was all about the International Court of Justice. Thank you. Bye-bye.